Muldrow, the U.S. Supreme Court rejected a heightened standard of what was called significant material or serious harm used by many of the federal circuit courts when deciding whether an employee suffered some sort of adverse action in the workplace based on a protected status. And in Muldrow, the Supreme Court held that an employment action is adverse if the plaintiff experienced, quote, some harm respecting an identifiable term or condition of employment. That means that the action must leave the employee worse off, but not necessarily, quote, need not have left the employee significantly worse off. The cases from the lower courts are now starting to filter out. Muldrow was a Title VII case. It was a race case. The 10th Circuit Court of Appeals, in the case of Shear versus Sisters of Charity, applied the same Muldrow analysis to an ADA claim. So Americans with Disabilities Act. And this is absolutely foreseeable that this would happen. The plaintiff refused to sign a counseling compliance form, and then her employer terminated her for failing to sign the counseling. The federal judge dismissed her ADA claim under the 10th Circuit's long-standing, quote-unquote, significant change standard. But on appeal, the 10th Circuit revived the case in light of Muldrow and said that the plaintiff in the case only needed to prove some harm, not material or significant harm. As supervisors were preparing her performance improvement plan to address certain concerns in her workplace, including multiple instances of failing to meet productivity standards, coworkers also had reported worries about her mental well-being. And so in response, the defendant in the case, the company, revised its PIP to require her to participate in its EAP for counseling. The court said that her refusal to sign, or the appeals court said her refusal to sign that PIP that required the EAP's disclosure form, that was some harm to her. And it's up to a jury to decide whether or not that constitutes disability discrimination. And so this leaves employers really in a precarious position. I mean, we know what the law is now because the Supreme Court has settled on it. But trying to figure out what the boundaries are of quote unquote some harm, that's going to be difficult.